we're going to start going through some questions that you guys already sent, and then we're going to grab new ones that are coming in. First one was, who's coming home because of the bill and how will they have to file a motion? So if your loved one is at the end of their sentence and they're getting expanded good time, that may shorten their sentence to the point where they're going to come home. They don't need to file anything. If your loved one is somebody who's going to benefit from the retroactive changes to the crack law, they will have to file a motion. I think in most cases, we've seen this in the past where the public defender's office, the federal public defender in your area, will start looking to see who in the district is eligible for relief, work with the prosecutors and file those motions. But they will have to file a motion. It's not automatically granted. I don't think there's anybody else who's coming home right away.
Not right away, but just on the file the motion part, if you do have a loved one who has been denied compassionate release,
yes,
they now have the right to appeal to the courts. And so that is another sort of legal mechanism that will have to be put in place to gain benefit from this provision. But as soon as the president signs, they'll have that ability.
And so stay tuned about compassionate release. We'll probably talk more about that, but also look to our page, both our family's page, for information on how to apply for compassionate release, what the new rules mean for your loved one. We are going to aggressively try to get people out who have applied and been denied, either by applying again or by going to federal court. And we're going to sort of have more instructions on how to do that. Another question that came in from Sherry Davis. Shout out to Sherry if you're watching. What's the new good time credit and where does RDAP fit in? That is one of the ones I mentioned. The difference between good time and earned time. Good time goes to everybody but lifers. It's 7 extra days a year than they already are getting, so they'll get 54 days a year. Earned time is a separate thing that you have to take programming for, and it doesn't reduce your sentence. It only allows you to get to a lower form of custody. There's a lot of exclusions. We have those listed on the page, but I know you have a lot of questions about that. So thanks, Sherry, for that question. Clarify the final amendments to the bill, especially on the exclusions like 924C. That came from Angela Coleman. They originally, the earned time credits were going to go to some people who had 924C offenses. That was added to exclude those people. So we are disappointed with that. We don't think anybody who's coming home should have been excluded from those credits, but they did that. So the 924C people, their only benefit that they're going to receive is the expanded good time.
Yeah, and the final amendment for those who are paying close attention to the floor and floor process, and I know a lot of you were, there was a final amendment that was added on the floor right immediately before final passage. It was done by unanimous consent, and it was offered by Senator Cruz and Senator Langford. This added just a few more exclusions, and I believe what happened was they were intended to go into the bill before the floor process, but there was a snafu. And those were carjacking. So previously, if it was carjacking that resulted in death, you couldn't be excluded. It's now all carjacking. And then several others that are more obscure and less charged, such as destruction of a motor vehicle facility, destruction of an airport. And there was also threats against the president and threats against former presidents are long excluded. So it for those worried that it was a substantial amendment,
right?
It was more of a clarification to what Cruz had thought would be in it. And then Senator Langford got some expansion of faith-based programs being able to get into the prisons.
Members of Congress just wanted to make sure that nobody who could conceivably be convicted of a violent crime were going to get this earned time credit. And so that's why they just added more scary sounding crimes to the list of exclusions. Again, it makes no sense. We should be getting programming to anybody who's coming out so they're less likely to reoffend. But that was a political compromise they made.
And all three of the really bad amendments that Senator Cotton and Senator Kennedy offered were resoundingly defeated on the floor.
So, what exactly is retroactivity, and is there any in the bill? And if not, why? So this is something that I've learned over the years, that most people think that when Congress passes a law to change sentences, that of course it applies retroactively. The truth is Congress has never done that. As frustrating as that is, and it makes no sense because for a lot of you, your loved ones have served these terrible sentences. In a lot of cases, we've told those stories and we've used those stories to change the law, but then they haven't applied the law retroactively to help those people who were serving those long sentences. It's outrageous. It shouldn't happen that way, but that's the way it's been. The crack retroactivity that's in this bill is the first time that Congress has made a law retroactive in my lifetime. it took 8 years to do it. I would take from that just a sign that it can be done, and that just because these provisions aren't, the other ones aren't retroactive now, doesn't mean we can't fight for those later. And we will do that. So that's only the crack changes are retroactive, and the good time is retroactive. Everything else is just for future crimes and offenses. What you want to ask? What you want to do that one? What's there?
For those who are due to be released upon passage immediately, upon passage, how can we get the BOP to release them, especially with the president giving federal employees a holiday on Monday? We want and deserve Christmas together, from Judy White.
That's a hard one.
Yeah.
We're not sure how BOP is going to implement this. It's going to take a little time. With 180,000 prisoners, what they're going to have to do for the expanded good time is the Home Office is going to have to recalculate their good time. So my guess is, even if he signs it, tonight, it's going to be hard to recalculate sentences for everybody in a way that then's going to allow them to get released. I hope that happens for some. I don't know if that's likely though. That's the only way they would get out now. Is the other thing is, most of the people who are getting out early because of the expansion of good time are probably already in halfway houses. And so you may go to your halfway house now and say, I expect to have my sentence shortened as a result of this bill. I'd like to go home ASAP. That may be possible. Most people who are going to go straight home as a result of this are probably already in halfway houses or in home confinement already anyway. So, but that's a good question. And I imagine everyone's anxious about the holidays. Once the bill is signed into law, what would be the next steps for an inmate filing a motion? That's from Christian Thompson. Thank you for that question. Again, in a lot of cases, it's going to be reaching out to the public defender's offices, because they're already watching the bill move. They know who's going to be eligible. I would caution you that there are going to be a lot of attorneys who are going to send letters into the prison saying, I will file a motion for you for thousands of dollars. I would urge you to exercise caution. We never recommend paying for services like that. That's your choice. But just know that in the past, public defenders have provided that service, and we expect them to do that here. And there's not even going to be that many that are going to need motions filed. We think there's roughly 2,500 people who are going to be eligible for the crack retroactivity, and that's the only one that's going to require motions, I think.
Yeah.
Unless compassionate release.
Compassionate release is appealing, but other than that, the good time should go automatically.
Earn time. Okay, earn time, explain. People are asking, when doing their sentence, at what point are they eligible to cash them in?
Yeah, so a couple factors play in here. First, your earn time credits have to equal or be greater than, I suppose, the remainder of your sentence. So once you've gotten to a point where you have enough earn time credits to be transferred for the remainder of your sentence, they become, I guess, eligible to be cashed in. However, there are some qualifications. You have to have been determined low or minimum risk for 2 reassessments in a row. Or if you're above low or minimum risk, or haven't had 2 reassessments in a row, you can cash in your credits with permission of the warden. So it will obviously be much easier to cash them in once you're low or minimum, because they have to let you out at that point. They have to let you cash them in. But there is an opportunity that if you don't meet those criteria, to get out with the permission of the warden.
I should mention that some of you guys have asked how quickly this will happen. The BOP has a couple of years to get they have to create the risk assessment tool. Then they have to apply it to all 180,000 people who are in prison. They've got to beef up their programming. So it's going to take a couple of years to implement this. So things are not going to happen right away. So I don't think they won't be earning their earn time credits right away. I do want to mention one other thing, because I get these questions a lot and I appreciate it. FAMM cannot give legal advice. So we can tell you about the bill's provisions as much as we can explain it, and we'll also point you to other resources, and we'll create as many resources as we can. We'll show you bill text. But sometimes you guys ask, you give me the facts of your loved one's situation and ask how they'll benefit. That really qualifies as legal advice that we can't do, and we don't want to give you false hope, because the truth is we won't know all the facts of your loved one's case. Sometimes there's stuff in the court documents that we don't have time to research. So all we can do is just really tell you what's in these bills as best we can, hope that you can understand how that'll impact your loved one. And if you don't, please consult an attorney. It's worthwhile to do so if you do have questions. Also, your loved one's counselor at their prison is going to know a lot of this stuff soon and how it is being implemented, so they'll have answers. But just so you know, it's not that we don't want to be helpful and we don't want to, sometimes might have a guess how it could, but we have to shy away from that because we can't give legal advice. So thanks for your patience on that. Let's see.
Do one from.
Yeah, I gotta do that one.
So this is from Ellie Bowen Sanchez. Thank you for the question. For inmates currently awaiting transfer and have not been designated, what can be done to try to get them within 500 miles?
That's good.
That's a good question. At least to my understanding, with the bill passed and as soon as it gets signed, it will be BOP policy that when practicable and to place them within 500 miles, driving miles. So there shouldn't be anything that you would have to do extra step. There may be things to do if they do not get within 500 miles. But
well, and let's be honest.
Yeah.
First of all, I want to say you are a rock star on Twitter. I love that you're calling everybody out. So I'm glad you asked the question. Thank you for being such a zealous advocate. The 500-mile rule is something that FAMM pushed because we've been hearing for so long how far people were and how hard it was to visit. The rule right now is a BOP rule that says 500 miles, but it's as the crow flies, it's air miles. So you may have a 10-hour drive. So we said the least they could do to improve it is make it 500 driving miles so that it's a little bit closer. The more important piece of that is that BOP, once you were within 500 miles, said that's it. We don't have to do any more. The bill says if you're within 500, but bed space becomes available closer, they're supposed to move you closer. Now, what Daniel said is right, but I don't trust BOP to do this. I'm sure you don't either. We are probably going to have to fight during the implementation of this. So please keep us posted on your cases. You can see BOP releases a occupancy sort of chart every month that says where's bed spaces available. So if you're trying to move someplace and they're not, let us know. It's going to take a little while to do this. Also know that one reason they may not move someone is if there's a co-defendant at that place, or there's some sort of security risk, or if your loved one needs programming that's not available at that facility that you want them to go to. People had to transfer to RDAP to go to some facility, so that may not be possible. But if you think you have a strong argument for why your loved one should be closer and they don't need programming and there's no security risk and it's not happening, let us know, because we have a feeling that's going to be a fight, because BOP is not going to want to be moving people even though they're supposed to. So thanks for asking about that. The crack laws, what's new and what does it mean? The truth is, and this is from Donette Wright, thanks for writing, sorry for the pun. This is a limited group of people. In 2010, when Congress passed the Fair Sentencing Act and made the crack law changes from 100-to-1 disparity to 18-to-1 disparity, they didn't make it retroactive. Since that time, 8 years ago, a lot of people have left. But there's about 2,500 people who didn't get the benefit of that change, and that's who it's going to apply to. So there's no other retroactivity on the sentencing provisions, but that's the change in the crack law. And I just want to mention again, if you've just joined us, I'm Kevin Ring, president of FAMM. This is Dan Landsman. He's our director of federal legislative affairs. We're trying to run through as many questions as we can that you have on the bill. Remember, it's passed the Senate already with 86 votes. It goes 87 votes. It's on the House floor today, should pass any minute. And we'll go to the president, who we expect to sign it in the next 24 to 48 hours. Another question. How will this law affect people headed into prison now? Only the programming features. If you're headed into prison now, it means you've already been sentenced. And since none of the sentencing law changes are retroactive, it's not going to impact you. The addition of good time, 7 extra days a year, getting you up to 54 days of good time a year. And then the earned time credit, which allows you, if you're low risk and commit certain offenses, which we have laid out in our summary, then you can get to home confinement or halfway house sooner at the end of your sentence. If you don't qualify for those benefits, the halfway house or home confinement or community supervision, you might get extra phone minutes, commissary privileges, visitation. That's all left to be determined. But again, this bill's provisions are mostly prospective, which means it doesn't apply to people who have already been sentenced or who are in prison. Do we have another one there you want to do?
Is there additional RDAP time that can be received besides the 12 months? That's from Cassie Monaco. How are you doing, Cassie? The bill does not add to the RDAP incentives. However, if RDAP is included in the eligible programming for earned time, it's conceivable that you could get up to 15 days of earned time credit per 30 months in the program.
And BOP has been suffering from a lack of funding, so there's a wait list for RDAP.
Yeah.
So a lot of people are not even getting their full year off that they're supposed to. And so hopefully with the additional funding that this bill includes, we'll start seeing, more programs set up around the country so people will get their full RDAP credit. That is something that is a no-brainer, but so it won't be more time than a year, but some people are not even getting that right now.
And this is another good question. We were actually talking about it just this morning. Will good time be added to the 2/3 for elderly 64 years nonviolent crime first offender? So that question is about the elderly parole pilot project that was reauthorized in this bill and changed so that it's now you can get released if you're 60 years old and have served 2/3 of your sentence. The answer, as we talked this morning, is it's unclear at this point how they're going to implement it. So the law says term of imprisonment. We interpret that to mean 2/3 of the term that you were sentenced to, and not with good time calculated. However, it just isn't clear yet, and that'll be something that'll have to be worked out during implementation. But we'll get an answer to that. As soon as we
Also,
can.
and stay tuned. If your loved one hears from their counselor how BOP is interpreting it, let us know, and we'll share that with everybody else because other people will have that question. So we'll appreciate your feedback on that. Got a question from Alex Melendez. Thank you. That said, any changes to the Armed Career Criminal Act? There aren't any. That just wasn't a provision that they addressed in this bill. Home confinement and halfway house time. When will these changes come into effect? That's from Tiffany Williams. Thank you, Tiffany. I think we've discussed that. It's going to take a couple years for them to develop the risk assessment tool, to classify everybody, to figure out whether you're eligible, because you're going to have to be low risk or minimal risk. And so I don't think they can start doing that until that happens. I will say this, another provision that FAMM fought to put in when the House considered the bill was to direct BOP to send low-risk inmates to home confinement as quickly as possible. What happens now, and they did this with me when I was I was in prison for 1.5 years, and when I was getting ready to leave, they still wanted to send me to a halfway house, even though I had a job and a home, and I didn't need the halfway house services. And so we had to fight to go straight to home confinement. I know a lot of you who have low-risk loved ones who are in camps and the rest don't need months and months of halfway house time. Then there are other people who are serving decades who do need more halfway house time, and they're not getting it because people like me are clogging up the halfway houses. So we have language in the bill that directs BOP to send low-risk people straight to home confinement for as much time as they can get it. And so we hope they do that, and that'll clear out some of the halfway house space for those who need it. Okay. Will good time credit be retroactive for all programs or not all? This is from something Sanchez. I'm sorry, I can't read that, but good time credit is not tied to programming. So that was what we talked about earlier. There's two types of credits. It's good time credit and then earned time credit. Earned time credit is tied to how much programming you do, and then when you succeed, you can go to a different form of custody. Good time is for everyone except life sentence serving prisoners, and so that gets expanded no matter what programming you do. It's just a count of good behavior. BOP will account for that right away.
Lakita Yokum asks if they were denied via drug -2, would they qualify for this one? So I assume you're referring to the retroactive application of Fair Sentencing Act. They would qualify if their offense was below 280 grams and above 50 grams. They should be eligible to apply for a resentencing hearing in the courts. For other drug offenses, depending on what the specific offense was, they could be eligible for the earned time credits. They will be eligible for the good time credits. But as far as reducing the sentence, they would have to been sentenced under the old crack threshold, which is 50 grams. It's now 280. So if they fell between that range, then they should be eligible.
All right, I've got a question from Mavis Lois, I believe. How does the bill help violent crimes or offenses, or is this bill for nonviolent offenses only? The bill really is for nonviolent offenders. We don't make that distinction at FAMM. We know that not everybody who has a gun or does some of these offenses are violent offenders, and that even if you committed a violent offense, that doesn't make you a violent person for the rest of your life. So we would not have these distinctions. We would say anybody who can become rehabilitated and take programming should be able to benefit. This is a political compromise. There are people who just do not want to do anything that helps anyone who has committed what is considered a violent offense today. So that's a project for a longer term. The bill, though, so the only provisions, again, that will help everybody is the expansion of good time credit. 7 more days a year, it's up to 54 days now. Only people who are serving life terms don't get that. But
I'd add that the compassionate release, and this is confusing the way I put it in the bill. So the elderly parole pilot does have an eligibility requirement that they be nonviolent, but compassionate release does not. So all offenders, with the exception of life, or even with life?
yeah, I think exception.
With the exception of life, qualify for compassionate release if they are elderly or terminally ill and they're able to apply. So the expansion to that will also affect them if they fall ill.
Claire Rosenberg asked about the 500-mile rule. In case you just got on and we answered it, it used to be 500 miles measured air distance. Now it's 500 driving miles, which is closer. More importantly, if you're within 500 miles and a space opens up closer to your house, they're supposed to move your loved one closer to you. Again, there's common sense restrictions on things like if you're a co-defendant in a case, or there's a violence issue, or you need programming that's at a facility that's not closer. But otherwise, please stay in touch with us on that. We asked for that provision. We fought for it. We want it. We want people to be closer to home, and we want to make sure it gets implemented correctly. So please be in touch about that.
So this is another good one that we should just do periodically throughout this live cast anyways. From Nessa May, asking to clarify any changes to mandatory minimums, enhancements, and stacking. So there are 4 sentencing provisions in the bill. The first one reforms the 841, 851 enhancements for repeat offenders. So currently, if you have a previous serious drug felony and get a second drug offense under the 841 10-year mandatory minimums, you can be enhanced to a 20-year sentence. If you have 2 priors, that can be life. Under this bill, the 20 years becomes 15 years, and the life sentence becomes 25 years. The second reform is to 924C stacking. And what this does is clarifies that under 924C, there's a 25-year mandatory minimum for a second or subsequent 924C offense. Currently, you can get that 25-year enhancement even if it's your first proceeding, but if you have multiple 924C charges, this clarifies that your prior 924C offense has to be complete, the conviction has to be final, and your sentence has to be served. Third, there is the expansion of the safety valve. What this does is it broadens the criminal history aspect of it. So currently, if you have greater than 1 criminal history point, you're ineligible. This expands it to 4 points, and it excludes 1-point offenses. However, you're ineligible if you have a 3-point criminal history offense or a 2-point violent offense. And yeah.
I mean, that's pretty technical.
Yeah.
So you're going to have to, figure out, if your loved one, this is going to be for future. If you're in already, this is not going to apply retroactively. The safety valve doesn't apply retroactively. The 924C and the expanded safety valve, 841, 851. And I know there's a bunch of 851 people who are have written about, is this going to help lifers? And because it's not retroactive, it will not. So even though somebody sentenced today for the same exact thing would get 25-year mandatory minimum instead of life, this bill does not apply retroactively, so they're not helped. This is why we need clemency in these cases. We're going to be urging the president to look at the people who would have benefited if this bill were retroactive and instead aren't getting help because it isn't, and look at those cases for retroactivity. And so, obviously we think it should be retroactive. It's not. Becky asked about the Cruz amendment. I think Daniel addressed this on the floor. Senator Cruz just added a host more of violent crimes to the exclusions for the earned time credit. And so it wasn't as big a change, I think, as people feared, because it seemed like it was secretive and we didn't know about it and there wasn't a vote on it. But it was something he had in the works anyway to get his support for the bill. And if you look on the summary we've prepared, which will be on the page, you'll now see the full list of exclusions that includes the Cruz ones. They're not going to affect that many people. But the thrust of what these guys were trying to do was exclude anyone who had committed anything that seemed like a violent offense from benefiting from earned time. Again, we think that's a mistake, but that's what they did. You want to do the next one?
Yeah, Tammy asks, I'm confused about the halfway house and home confinement. My brother is in a camp due to go to a halfway house in March for a year. With a good time credit, could he get to the halfway house earlier? You mentioned it could take 2 years for this to take place. So thank you so much for the question. First, I'd like to just reiterate the difference between earned time and good time. So good time everyone gets, and that's time off your sentence. What would help people get to halfway house earlier is earned time, and that's credit that you can exchange for pre-release custody, and you receive that for completing programming. It could take up to 2 years to implement. At the very least, it'll take 6 months because the DOJ has 180 days to develop the risk assessment tool, and the earned time credits can't come in until the risk assessment tool is up and running. And I imagine they will take that full 180 days because it's going to be a complex process. So it may not be up and running by March, unfortunately, to help.
But I'll say this, a good friend of ours who's a member of this group, Vita Jamu, her brother served 25 years. He was supposed to get to a halfway house in September, or his release date was going to be in September, and he was supposed to go to a halfway house early next year. With all of the good time credit that he amassed, and once that's applied retroactively, which it will be, they're going to send him out a lot sooner. They're going to, if they want him to have any halfway house time, they're going to have to send him to that halfway house even sooner. So, especially for those who've been serving long sentences, this could move them to halfway house and home confinement sooner, even aside from the earned time credit. So it just really depends on the length of the sentence and how quickly your loved one's case manager can move this stuff, and whether there's availability at the halfway houses in your area. A question that a number of people asked, this is from Shay Wright. I read that sex offenders are not getting anything. True? Again, sex offenders will get the same increase in good time that everybody gets. They will be excluded, as will all the other offenders you'll see on our list of exclusions from the earned time credit provisions. There are no sentencing provisions that are applying to sex offenders in the bill, prospective or retroactive. So the only way they're implicated is through the good time, and they will receive good time. They just won't get earned time. Am I missing anything there?
Nope.
All right. You want to do one?
Do we know how many people this bill will apply to? So the United States Sentencing Commission the other day, I believe yesterday, released their sort of impact analysis on the most recent version of the bill. That'll be up on our website later today, and we can share that in the Facebook group. So for the earned time credits, they estimate that 106,114 offenders will be able to receive earned time credit. Again, the good time credit is going to impact everyone who isn't serving a life sentence. I guess I can real quickly, the 851 reform will impact 56 offenders annually going forward. The safety valve will impact about 2,000 going forward. The 924C will impact about 57 going forward. And the FSA retroactive should apply to 2,600 offenders. So
you do this next one because it's another one clarifying the good time.
So Bill Taylor asked, I'd like to know if the adjustment in good time credit from 47 days to 54 days will be automatically and retroactively applied to every inmate across the board except life. Yes, that is how it should work. As soon as this bill goes into effect, the BOP should be applying those 7 extra days retroactively and making it 54 days going forward. It may depend, facility to facility, warden to warden, and what the counselors, how quickly the counselors get this up and running, and case managers. But that is the intent of the law.
And you all know how this works. If you go to the BOP inmate locator and you find your loved one, there's an out date. That out date is their good date, their good time date, which means their sentence minus good time. And so you'll see if that changes in the next few months, or your loved one's going to get notification from the case manager and might find that out sooner. But our expectation is that they'll go to Grand Prairie, which is their home office, where they calculate all this. They will make that adjustment. They should apply it retroactively, and hopefully they'll hear that sooner rather than later once this is signed into law. I'm curious how assessment will work. This is from Kelly Halverson. Hey, Kelly.
Oh, hey,
welcome. The incentives seem to be leaning toward low risk. Curious about the determining parameters, I believe you said. So risk assessment is a somewhat controversial concept, although the Bureau of Prisons already uses a risk assessment tool to classify people, so to decide whether you're going to go to a camp, a low, a medium, or a high security facility. This bill will require them to develop a new tool that will be based on a whole bunch of factors, including offense type, criminal history, age, educational background, all sorts of factors that will then be reviewed by an independent review board to make sure that there's no racial bias or any other unwarranted bias that comes into that decision making. And then, yes, it'll classify everybody in low, medium, high, and only people who qualify as low risk will be able to cash in their earned time to get to a lower form of custody. People who are high or medium will be able to get the other incentives, and they will also be able to program their way down to low risk. They'll get reassessed periodically to see if they can move down to low risk. So the idea is not that people will be static, but through programming, they'll move down to become a lower risk and then can benefit from the other incentives.
And in the development of the tool, there's language in the bill to prioritize dynamic factors over static factors. Yes. So static factors are things like the crime you committed and age at the time you committed the crime. And they're going to focus more on dynamic factors, which are things like that parts about you that change, like your age at the time of assessment, or things that you've done through programming. So there's going to be an emphasis on that, so that there's a greater chance of people being able to rehabilitate themselves downward.
All right, let me see. I don't know if I have any more here.
There's one here. Does the safety valve apply to those who have been charged with the 924C and haven't been sentenced yet? Will they be eligible for what the bill is offering? And that's Asia Devon. Hi, Asia. Thank you for that. Unfortunately, the safety valve still has a requirement that no firearm be used in the commission of the crime. However, if the person you're asking on the behalf of hasn't been charged yet and it's their first proceeding and they have multiple 924C charges, their sentencing will be different under this because they will not qualify for the 25-year mandatory minimum. But other than that, unfortunately, safety valve still has some requirements.
And if they've already been sentenced, it's not retroactive, so they wouldn't benefit. But I don't know if that was sentenced or not. Any word on how this law will reduce mandatory minimums? So we've gone through the sentencing provisions. Daniel mentioned 924C, that they won't stack in the same way. 841, 851, instead of getting a life sentence for a third offense, you'll get 25 mandatory minimum. Instead of 20, you'll get 15 for a second. These are small, modest changes. The other thing is, we have said in the past, this bill doesn't get rid of any mandatory minimums, but in some senses it does, because if you have limited criminal history, right now you'd be excluded from getting the safety valve, but now you can have up to 4 points and the judge can bypass the mandatory minimum and give a right-size sentence. So that's the only way it'll reduce mandatory minimums. And again, that's just prospective. It's not retroactive. So if your loved one's already been sentenced, it won't affect them. Again, it's been a while. Thank you for joining us. I'm Kevin Ring, President of FAMM. This is Daniel Landsman, our Director of Legislative Affairs. We're trying to answer all your questions about the First Step Act. We know we won't get to them all. We've answered a lot so far. We're posting materials that hopefully will help you review the bill. Also want to say, if we don't get to your questions and you write them, that'll be flagged for us, and we'll make a frequently asked questions sheet that we'll post that may be helpful with the most commonly asked questions if you've already missed one that we've answered. And also just a reminder that a lot of people have written to me sort of separately to ask about your loved one's specific case and how the law will apply. We can't give legal advice, so I can't tell you that because I just can't possibly know all the facts and circumstances of your loved one's offense, and so we can't give that type of advice. All we can tell you is what the bill does, and we'll try to do that to the best of our ability.
So I do want to address this question. So Angela Coleman asks, my earlier question was actually regarding 924E, the Armed Career Criminal Act. I saw somewhere those were excluded, but then didn't see it anymore. Can you clarify? So originally in the House passed version, 924E was excluded. The text currently does not have it in it that I'm aware of. So I'm going to double check to make sure that it really isn't in there. But in the last version of the text, it was no longer amongst the exclusions unless I personally missed it. So I will check again, but last I saw it had been removed. I don't know if that was on purpose or by accident, but either way, I'm not complaining.
Yeah, well, and we'll post the list of exclusions that's in the final bill, which is going to be approved any minute by the House. And remember, even with 924E, and when we're talking about exclusions, that's just about earned time credit. That's not about good time. Everyone gets expanded good time except for people serving life sentences.
So Edna Harris asks, well, my loved one applying for compassionate release this past June and has heard no response. Could he apply again? although there's been no response from BOP.
Well, the most important thing about this is the thing that we thought was most important was that if they got a negative determination, that wasn't going to be the end, because once they exhaust that remedy, they can go into court and ask a judge to make the decision. But the bill also puts in strict time limits for getting responses. So Edna, if your loved one is not even getting an answer, not even getting it denied, that is going to change.
Yeah.
They're going to be required to answer
30 days.
30 days.
If
So
it's 30 days, you have the right to appeal to the courts. And yeah,
so I don't know if when the clock will be considered running from when you submitted it, or if you have to submit another one, but stay in touch about that, because that's going to come up a lot, because you guys might have seen the statistics. One of the things bothers us so much about compassion release is, I mean, one, it's just inhumane to let people die in prison cells when they're no threat to the public. But there was a study recently that showed 81 people died waiting to get a response to their petitions, which just shows you one, how slow BOP is and how little risk these people were. They were really at the end of their life. And our view is, even if you are not compassionate toward the offender who is in prison, their family has a right to have their loved one with them in their final days, to have that closure. So we feel very strongly about compassionate release, and we will be jumping all over this. We're already pulling attorneys together so that we're not just sort of giving you advice about this, but that we can hopefully match you with people to help guide you through that process.
and then final question here. Heather Lanier asks, can someone with a fentanyl charge earn time off through programming? Unfortunately, they cannot. This was a addition made during the Senate negotiations. Originally, it was fentanyl, people with a fentanyl charge who were leader or organizers. Unfortunately, there are a lot of hardline people, even people who are ally in the general criminal justice reform fight, view fentanyl differently for whatever reason. And so they eliminated all fentanyl charges under 21 USC 841 and the Import-Export Act, which code I can't remember. And so if you have a fentanyl charge, you cannot earn time from programming.
Let me just say, this is obviously a political compromise that they made. Even in Massachusetts this year, they passed a sweeping criminal justice reform bill that got rid of a lot of mandatory minimums, but they added it for fentanyl. This is what happened with crack when it's sort of the crime du jour is centered on that drug. They always make penalties harsher. But I will just say this: a lot of people are saying this bill is very limited, or it's sweeping. And I just want from our perspective, this bill doesn't scratch the surface of what needs to be done in federal criminal sentencing reform or prison reform. It really is just a first step. But the important thing is the direction of the step. We're finally moving away from longer sentences for everybody, warehousing people with no thought about programming or how they're going to do when they get out. So I know a lot of you are thinking this isn't a huge benefit to my loved one, or in some cases it's not going to benefit them at all. And I don't want you to be discouraged, because we should take from this that 87 senators in a Republican-controlled U.S. Senate felt like they had to vote for criminal justice reform. A president who ran on law and order and executing fentanyl dealers is going to sign a bill that's going to shorten sentences, even for people who use guns in their offenses. So it's not, it's not a jailbreak, as Tom Cotton was saying. It's not that sweeping. It's not so modest that people aren't going to be helped. Some people are going to be helped a lot. They're going to have loved ones home sooner, have loved ones closer. For compassionate release people, they're going to be able to have their loved ones home with them in their dying days. So they're going to be very real changes. But what should encourage people is that we've changed the direction. At least people are now thinking there was only 12 no votes. That's pretty great. And we just got to keep educating people so we don't get these political compromises that deny your loved ones access to programming, which they should have. In our view, when we started this process, when they talked about exclusions, we said the only exclusion should be if you're not coming home. But if you're coming home, we want you to come home better and have tools and resources, so we want you to get programming. Obviously, the political compromise that had to be struck was people started listing all the scary sounding crimes. But I just want you to not lose heart about that, because overall this bill makes progress. It's a small start, but it's the right direction. You're seeing states pass sweeping sentencing reform, some of which we've been part of, some of which we've watched and cheered, and that we're getting involved in the future. And we'll talk more about that. But I know this is going to be frustrating for some people who aren't going to benefit personally from this bill, but I hope you take heart that we're at least moving in the right direction.
So we're going to bring in Tanisha, but first I saw a question come up and then disappear, but I'm going to answer it anyways because it's important. So good time is retroactive, earn time is not. And so there's a provision in the bill where you cannot get earn time credit for programming that has been completed already. So while good time, it will go back and you'll get 7 additional days. For earn time credit, programming already completed will not count towards earn time credit. So thank you all for having me. Feel free to reach out in the Facebook group if there are any other questions. And please welcome Tanisha Williams.
All right, thanks. Hey, she's not going to be mic'd, right? So we're just going to do without?
Yeah, she will just clip it on.
No, Lonnie.
Oh, correct.
Okay, so do it or no?
Yeah, we can put a mic on her. That's what.
Okay. So everybody, thanks. I know you probably still have more questions. Some of you joined late, so we'll keep answering those. Like I said, we'll get an FAQ out with the frequently asked questions and answers. But a lot of you guys are talking about, and thank you for everybody in the page who has loved ones in state prison who are like, hey, this is great, and you've made calls for us and you helped win this fight, but you were not directly impacted. We are not forgetting about you. We are fighting in states, some of which we can talk about. But I really wanted to bring in Tanisha because you might not have seen her in a while. She's the one who's organizing all these efforts. And Lonnie Punez, who some of you talk to every day, but I don't know if you've met. She does our social media. And she also wants to be in conversation with you about how we can do a better job of responding to your needs and helping you in the Facebook group and other things. But I'm going to start with Tanisha and let her tell you what we're up to.
Hey everybody, it's so good to see all of you in our chats and in our comments, talking and asking questions and being so involved in what we're doing. First of all, I just want to shout you out for the incredible work that you've done over the last 6, 7, 8 months with the First Step Act. Everything from the rally day to lobbying and talking to your legislators to writing letters and making phone calls, flooding people's offices. It's been amazing to see since I've started how active and engaged you are and how committed to this fight you all are. So I'll just want to jump in and let you know some of the things that we have coming up, and of course hear from you. That's super important to us here at FAMM as we continue to organize and mobilize families. We want to know what you feel like you can do and what you want to do. So we do have our Justice Now Action Center. Many of you have visited and become an advocate. Sign up for our emails. That is right now the best way to get all the information about what's happening with form letters and call-in days and rally days and lobby days. So make sure you are signed up for our emails. And if you are signed up for our emails, take it a step further and send the link to a friend and tell them to sign up for our emails too, so that we can be more powerful with the more people we have to make sure we continue to fight, not only at the federal level, but also at the state level as well, because we know that impacts so many of you also. 2019 is coming and it is going to be super powerful and exciting. We just hired a new digital organizer who's going to really help us make sure that you feel like you have a community, not only within your local space, but across the country with other people who are just as impacted as you. So we're excited. We want to hear from you. Make sure you're in the comments. Tell us what you want. If there are video trainings that you feel like may be helpful in terms of understanding how a law becomes a bill, or understanding who your legislators are, how to reach out to them, those are things that we can do to make sure that you're equipped with the tools that you need to continue this fight that y'all already are in.
And I just want to say, we are incredibly grateful. There was somebody who came in the Facebook group today who was about to be sentenced, and she came in and said, this is happening to me. And just the love that was showed to her, so many people have commented to us that they felt alone until they found the group. That's exactly why it's there, is to let you know you're not. We posted the study recently from Forward US. 113 million Americans, 1 out of every 2 adults, knows some immediate family member who's spent at least 1 day in prison. All of us are impacted. Even the ones who haven't been in prison are impacted by this. And that's the force we're trying to rally. And the group has been incredible. Even when we're not there to answer questions, you all are helping each other. And that's exactly what we're hoping, to create those networks. I've seen some people organize carpools to visit their loved ones together. That's amazing. And as we grow, and we are growing, we're over 2,300 as of last night. We're going to be able to do more things. And the other thing is, I would say, is the sharing is great and the support that you give one another, but that name of the page is intentional. It's Families in Action. And that's what Tanisha's talking about. We want to provide support and information and make you better informed, but then we're going to ask you to take action. I know so many of you have asked how you can do that. We're going to try to keep giving you those opportunities. And so we really appreciate that. Along those lines, I want to make sure that you know more about the FAMM team. Every time I post in there, everyone's very thankful to me. I appreciate it. It's very good for me. I don't get any love from my kids like that, so it's very helpful for my self-esteem. But we have a huge team here at FAMM that is doing all this work, and I want you to get to know them better because they can be a resource for you. You guys know that Lonnie is always posting stuff into the group when she sees that you guys need stuff. Daniel, who was just here, who does our federal legislative affairs, feel free to reach out to him the same way you do with me. Tag him. Sometimes I'll do that. You know that Anna Spuelas and Debbie Campbell are ready to work with you on storytelling and those sorts of things. Tanisha, obviously, if you want to get involved in any way or know somebody who does, want to host an event, anything, Tanisha is ready to help. Mary Price, our general counsel, can answer not legal questions about your case, but about questions about the law or Supreme Court cases. She does all of our litigation. So just feel free to be in touch with us. We will try to pop up into the group as often as possible and identify ourselves. I know it gets repetitive, but so many new people are joining, we do that. Lonnie, what do you think we need to share?
Yeah, so I think the biggest thing for everyone to know for 2019 is that this Facebook group is going to get bigger. And the biggest thing that you can do to be helpful is to be patient with people who are brand new to the subject or are just not as informative. Feel free to tag us if they have questions that you're not sure about. We are so thankful that everyone in the group is being such a great resource for everyone. But definitely feel free if someone's new and asking basic questions, tag us. We can help onboard people to where we all are at. But otherwise, I'm here as a resource, not just for information and trying to get people's attention for you and things like that, but also social media is one of the tools of engagement to get other people on board, to get people to call their lawmakers. Always feel free to reach out to me for technical questions. How do I share something correctly? How do I get this link to someone? How do I, join Twitter so I can follow you there? All of those questions are totally valid. They are a part of learning how to be a better advocate because not all of you have the time and the money and the space and energy to do some of the other actions. But social media is a tool for social action, and I'm always here to explain something to you. There's literally no question that's too dumb. Social media is complicated and it's hard, and not everyone's good at it. And not only are some people here who are on staff helpful for the law and the background litigation, but the people here who are technicians who can help you figure out the basics of how to get involved in the Facebook group, Facebook page, other social media, how to get good at it, how to engage us better on there, helping us share stories and things like that. So we're here as a huge resource for so many different things and so many different subjects. So please feel free to reach out to any of us for any of those things. We're trying to expand the way we help you. Feel free to always give us feedback, even just about social media, about how we can inform you better. We want to be the best resource we can for you all.
And I just want to quickly shout out Molly Gill, who was in there with policy answering questions. Rabia, who's our director of communication, was in there in the group as well. Evans and Celeste, who are our Pennsylvania organizers, are also in the group sharing resources. So you have a full squad of people who are in your back pocket, ready to work with you to make sure that we can continue to fight for criminal justice reform.
And I'll just close with this. We have huge plans for 2019. We had our staff retreat. Sorry, we were so out of pocket yesterday. We had our staff retreat planning our agenda and our program for 2019 and beyond. And so we'll still be working at the federal level. That we have to get this law implemented correctly. You're going to be a huge help in that regard because you're going to hear how it's going. Also, our state work. We're focused in on a few states, but we're happy to start helping people build armies of committed advocates in any state where we have the time and energy to do that. So be in touch with us. We are not focused just on federal. We just had this long fight over the federal bill and the states are out of session, but we will be back. Let us know of opportunities in the states that you see, and then you'll be seeing from us more information about what we're doing. So we're just very grateful for you all. Does anybody else have anything they want to add?
Oh,
Thank you so much. Remember, First Step Act should be signed by the end of this week. We ask you to take care of yourselves. This has been a very stressful period. A lot of you guys have been watching this bill like you've never watched federal legislation in your lives. You guys have learned what floor amendments are and cloture and all sorts of processes that you never knew. That's great, and we really love your engagement. But take time to take care of yourself. I know how stressful it is having a loved one in prison. The holidays are coming. We really hope you have a great holiday season, and we look back to hitting it when we get back in January. So thanks very much.
Bye, everyone. Thanks for joining.
Are we done?
I just don't want to. I don't want to do it.
It's still rolling.
Yeah.
Rolling.
Hi, everyone.
Hey.